Welcome back to the PI show. Before the break, Tony, we were talking about a case decided in the Supreme Court in Victoria 2010 about a accident with a mare on a farm in Victoria.
Yes.
And look, the judge was very thoughtful in the way he approached the issue of liability, and he found for the plaintiff.
I think it's a sensational decision, not because the plaintiff won, but because he's had all this literature about industry standards and things like that.
Yeah, but with the birth, when mares give birth, usually there's only one person in attendance. But the judge...
That was industry standard. But then, because the risk of a significant injury was there, he sort of...
There are alternate ways of doing it.
In his view, two people should be present.
Yeah.
At the birth.
Yeah. So, look, she was 60... The incident was in 2002. Bizarrely, it took 8 years to get to a trial.
It is a long time.
It was heard in 2010, and the judge awarded significant damages.
She got a lot of money for general damages, but by the time she got the trial, she was at the end of her working life effectively. So she didn't get much for the future.
She got $25,000 for the future.
And most of her compensation was for the significant pain and suffering and loss of enjoyment of life. General damages.
So the general damage was $250,000.
Yeah, which is pretty significant, really.
Yeah, and I think there were nasty facial injuries, and
although she had a fracture of the forehead, so it was really nasty.
Quite nasty, and so the second case is again a accident on a farm. This time involving a accident in a shearing shed. It was what I'd call a general labourer. He was helping out in the shearing shed. He wasn't shearing. And at some point in time, on a particular day, he slipped on some stairs, getting down from a platform.
On a platform where they used to shear the sheep.
Where they sheared the sheep. And he then subsequently had a back injury, landed on his buttocks, had a back injury, 27-year-old.
A very colourful character, Mr. Richards Harry. He was a cocaine user, and I think he experimented in every type of drug.
Well, this was a lot of time was spent on his credibility, Tony.
And shocking, wasn't it?
Defendants had a go at him, firstly because they said there was no witnesses to the accident.
Yes, that's a big issue.
And how did the accident occur? He gave different versions to different doctors. So that was held against him.
He was very inconsistent in a lot of things he did. He denied drug use, and it showed up in the blood samples and urine samples at the hospital. He, like you said, he gave so many different versions of how he got injured.
And cash in hand, or the income he was earning before. He's 27 years old. How much were you earning?
Yeah,
he was pretty evasive about it, Tony.
You wouldn't know, because it sounded to me that there was quite a bit of money under the table.
In the farming community he was living in.
I think so.
But he was evasive about how much money he was earning. And then he was exaggerating, the judge found, I think, about his level of disabilities. Walking with a walking stick.
Yeah.
And the judge didn't quite believe how significant the injury was.
I think he's very fortunate, because reading the judgment, there was a lot of things not to like about this bloke.
Well, I think the judge made findings. The plaintiff was untruthful.
Yes.
It's pretty strong findings.
Yes.
And I think the judge said he was untruthful in a lot of his assertions.
What probably saved him was his first trip to the doctor. What did he do, Harry?
Well, as soon as he fell, he was taken almost straight from the shearing shed to a GP, and the GP in his notes did record that he fell at the shearing shed.
Backwards.
Yes. So I think that saved him, because there was some doubt about what actually did happen with no witnesses to see.
But that was a contemporaneous note of at the time. Yes, and that was probably the most accurate depiction of what happened.
Yes. Yeah.
And
so the doctor got it right for a change, Tony?
Yeah. Oh, yeah, the doctor, fortunately for him, the doctor did take some detailed notes about how he got injured. Also, the judge made a lot of comments about the nature of the work and the workplace and the safety issues.
Yeah, but look, I think ultimately the judge found that they could have put a non-slip strip
Yes.
on the stairs that would have lessened the risk of the accident occurring.
correct.
I think the judge, although he didn't like the plaintiff, did the right thing and found that the defendant was negligent. It was, I thought when I started reading the decision, it was touch and go, but the judge ultimately probably made a sensible decision.
Even though we say that he wasn't, he didn't look after him, he did look after him because one, he found negligence, which entitled him to damages in the first place.
Contributory negligence?
Yeah, he knocked off, my memory of it was what, 15%?
15%.
Yeah. I'm not sure how he got the 15%.
Oh, because he didn't grab the handrails. There were some handrails, and he said he should have grabbed it, and that would have maybe prevented or
But he didn't look after him
diminished
in terms of
damages.
Christian Kirkmeyer, which is, cost
Well,
of looking
how
after
much?
him.
Look, this is New South Wales law, Tony, which
Is different to
is
Victoria.
different to Victoria. But in New South Wales, you can claim the care someone's got to give you,
The care, that's right.
and how much
The
it's going to
commercial
cost
cost
you.
of care. Yeah, even undertaken by family
and
members.
medical expenses.
Yes.
So you can claim future medical expenses. So how much did he get in the end?
All up, he got 816,000.
Sounds
just
a
over
lot.
that. No, but then it was reduced by the 15% for his contribution to the incident,
Yeah,
and then obviously they took off what he'd already had in compensation.
over
So
5 years.
So he walked out with 462,000 and a bit. So it was a reasonably significant amount of money,
Yeah.
and his back was a nasty back, probably not as bad as some people we've seen. So I think he got a reasonable result.
He did, but he presented to the court and to the doctors in a pretty dramatic way.
Yeah, well, he was like a cripple in his presentation, and
And his wife was sort of with him and against him, or she was.
she was not that believable either. She wasn't that credible a witness as well, Harry. So, yeah, look, I think the initial notes with the doctor saved this bloke.
Yeah,
Very
yeah,
lucky.
no, he was, and judge alone, no jury.
Yeah, I think that's
Again, that would have
just
saved
as
him.
well for this bloke that he had a judge alone, because I think a jury wouldn't have liked him. That's the impression I get.
Yeah,
Yeah, is that how you feel?
Yeah. No, I agree. Judge alone was.
And the judge is a bit more sensible. He applies a bit of law. So, look, Harry, we might have to leave this case of Mr. Richards, and we've got to get all sponsors break. And after the break, we've got the mailbag. So, viewers, please keep watching and stay tuned. We'll be back very shortly. Stay tuned.